Good evening, everyone. Welcome to our day 8 of our bar review. We have exactly 181 days remaining in our bar journey. Today, we are diving into the very first topic of our syllabus in Remedial Law, the concept and nature. But before we get into the heavy legal concepts, let us ground ourselves with our verse for today. Commit to the Lord whatever you do, and he will establish your plans. That's Proverbs chapter 16, verse 3. Let this be our guiding light as we tackle today's material. Our discussion today will be structured into four levels as discussed in our day 4 of review. To help us properly digest the topic, we will look at the big picture, the essential pillar, the elemental principle, and the root level. Let's jump right into the big picture. For our big picture, we look at the general principles of remedial law. Why is it so important to understand these principles first? It is because they establish the foundational framework and the essential mechanisms required for the proper administration of justice. They ensure that our procedural rules are utilized properly as tools to facilitate justice rather than rigid technicalities that frustrate. Moving down to our essential pillar, we define the concept and nature of remedial. What is exactly is it? Remedial or procedural laws are adjective laws. Unlike substantive law which creates, defines, and regulates rights, remedial law serves to prescribe the specific rules and forms of procedure used for enforcing those rights or obtaining redress when those rights are invaded. Still, on our essential pillar, there are four key traits regarding the nature of remedial law that you must always remember. First, it has the force and effect of law. The rules of court promulgated by the Supreme Court carry the weight of law, provided they do not conflict with positive law. Second, it is the vital link of judicial administration. It connects the domain of substantive law with the actual, day-to-day administration of justice by the court. Third, there are no vested rights in procedural rules. A litigant cannot insist on the application of a specific procedural rule if it has already been legally altered. And lastly, because no vested rights attach to it, procedural laws generally allow retroactive application. They apply to actions that are already pending and undetermined at the time of their passage. For our elemental principle, there are no rigid rules in isolation. The rules are always subject to the overarching policy that they must not be applied to override substantial justice. This principle acts as the filter for everything we just discussed. At the root level, we see how these concepts operate in a real-world litigation and actual controversy. Let's look at exactly how this plays out in a practical scenario. To wrap up our discussion at the root level, here is a highly possible bar question that perfectly tests the concept of retroactive application. Let's read it together. In September 2018, Frank filed a civil complaint for the declaration of nullity of deeds of sale against Crisanta. In her answer, Crisanta invoked the affirmative defense of failure to state a cause of action and subsequently filed a motion to hear her affirmative defenses. The trial court initially denied this motion to hear affirmative defenses in February 2020. On May 1, 2020, the 2019 amendments to the Rules of Court officially took effect. Shortly after, The trial court issued an order dismissing Frank's complaint. The court reasoned that since procedural rules apply retroactively, it was bound by the new 2019 amendments, which mandate courts to motu proprio resolve affirmative defenses based on the failure to state a cause of action. Question: was the trial court's a retroactive application of the new procedural rules to Frank's pending case correct? Now, instead of giving you the answer right away, I am going to leave this with you as an assignment. I want you to apply the principles we just discussed today, especially the limits on retroactive application and how it relates to the vested rights and substantial justice. Think it over, draft your best beer style answer, and hold on to it. We will tackle this exact problem and discuss the suggested answer together after 3 days. Thank you for joining me on day 8 of our bar review journey. Keep studying smart. Remember our guiding verse, and I will see you all on our day 9 of review. God bless.